All right, hello and welcome to this evidence video capsule. In this particular capsule, I'm going to be looking at a very specific aspect of litigation privilege. And I should warn you, if you are not familiar with litigation privilege, I'd advise you go back and first watch my capsule that goes through the basic aspects of how this particular privilege works. In this capsule, I'm going to be looking at a very specific aspect of the privilege. In particular, whether the privilege can be upheld to stop claims to access information by a third party or a non-party to the particular litigation in which the communication in question was actually created. It's a very interesting question, and it was explored in depth in a case that I'm going to delve into. Dudley Estate versus British Columbia, a 2016 decision of the British Columbia Court of Appeal. So the facts of Dudley Estate versus British Columbia are pretty straightforward. They're also pretty tragic. They essentially deal with someone who was murdered. She was apparently involved in a marijuana grow operation in BC, and she was murdered. But the particularly tragic part is that she was alive and paralyzed for 4 days after being shot, and she was only discovered 4 days after the event by a neighbor. So she was suffering along that time, and she died afterwards. So the lawsuit that we're concerned with is that the estate sues the RCMP, saying they didn't act properly in investigating the shooting and the way in which it took place, and the merits of the case have no bearing whatsoever on this particular privilege application. Nonetheless, what is important is that 4 people are charged in connection with the case, and the trials are still in process as the civil case is moving its way through the courts. The criminal trials take time. They're going on slowly. One of the last people is being tried as this particular proceeding takes place. So essentially, as part of its investigation into the murder, the RCMP, not surprisingly, prepares some very detailed investigative files. And as you're not surprisingly, these investigative files are not disclosed to the accused in the criminal case. And the reason is that the Attorney General claims litigation privilege over the files. Now, here's the interesting part. The estate does not dispute that the files are covered by litigation privilege for the purposes of the criminal trial. Okay? But they seek production through the civil process. Everybody accepts that the files are clearly relevant to the case. And the Attorney General has no problem turning over the files once the litigation is done. And I'll show you why as we talk about the nature of litigation privilege. But the basis here is as follows. So what we have is a case where the litigation in question involves the Attorney General against the 4 accused, which I'll just call 4A. And there is no doubt, and nobody asserts otherwise, that the privilege covers this proceeding. The basic idea of litigation privilege, which I'll get into, is that it allows you to prepare for your case. So nobody disputes the material was properly prepared for the prosecution of these 4 individuals. And the issue is that Dudley Estate is what's called an outsider to these proceedings. So what I'm going to show you is their claim is that the litigation privilege does not extend to them. And to understand why, I'm going to need to show you how litigation privilege works. So here are the basics of litigation privilege, and it's important for newcomers not to confuse litigation privilege and legal advice or solicitor-client privilege. And, you know, one of the reasons that's so critical, and particularly one of the reasons I guess that's so confusing, is that in the past, the courts did not distinguish between the two, but over the last 20 years, they've been pretty good at keeping the two things separate. Litigation privilege is not the same as legal advice privilege, and here's the way in which it works. Essentially, litigation privilege allows you to prepare for your case. So when any materials are created for what's called the dominant purpose of litigation, those materials do not have to be turned over to the other side because they allowed you to investigate and fully discover what your case was about. Essentially, what they do is it gives litigants a zone of privacy. You go explore your case, content in the idea that no one else can have access to it, to be used against you. So essentially, one of the classic ways in which litigation privilege works is, you've been injured in an accident, go see a doctor and fully evaluate, perhaps go see 3 or 4 doctors and evaluate the nature of your injuries without having to worry that all the material will be turned over to the other side. Here's the thing. It's not like legal advice privilege, which I've put here. The privilege ends when the litigation ends, and the reason for that can be described as follows. Legal advice privilege is a very strong privilege, and it exists so that people can seek legal advice freely without any worry that anything they seek to, enforce or educate themselves about their rights will ever see the light of day. So legal advice privilege is very strong because the rationale is go seek help, learn about your rights, don't worry. You can even go confess to your lawyer. You never have to worry that will be used against you. But litigation privilege is different. It's not trying to protect the same interest. Litigation privilege is essentially to allow you to investigate confidentially so that your adversary, and that's going to become important in a little bit of time, cannot then use anything you discover against you in that proceeding. But the basic idea is that your freedom to pursue your case only extends to that litigation. It doesn't go any further because, frankly, if that information becomes relevant somewhere down the road, you don't need the privacy anymore. And therefore, the courts have upheld on repeated occasions, including the Supreme Court of Canada in a case called Blank versus the Attorney General, that once the litigation or related litigation ends, and I'll show you what that term means in just a moment, then there is no longer a privilege to protect and it must be turned over. So that's one of the most important distinctions between the two types of privilege. Legal advice privilege extends for all time because the rationale demands that it extend for all time. Litigation privilege is limited to the proceeding. And the last note that I've got over here, right at the bottom, that's important. The Attorney General concedes that the files are turned over as soon as the murder trials are over. They need the zone of privacy to proceed the murder claims, but they don't need them afterward, and that material will have to be turned over to Dudley Estate. But of course, Dudley Estate doesn't want to wait, which is what brings this particular motion. So here is the primary issue in the case. Does litigation privilege only protect against the direct adversary? So to go back to that diagram that I had earlier, you had the AG and the 4 accused. There's no question that the privilege extends to protect against the accused getting the material. But Dudley Estate is an outsider. Does that wall exist to prevent them from getting the material? They're not a party to the proceedings, nor are they a party to related proceedings. And just to tell you what I mean about related proceedings, that has been very, very narrowly interpreted as well. Again, you need to have the ability to prepare for anything that might affect you. So if you are a litigant and there may be a potential of 4 claims, let's say you have you're a construction company and a building collapses, well, there will be multiple claims against you. So you're not just protected against claim 1, you're protected against any claim that comes against a related proceeding involving the same basic issue. But that is not an issue here. Dudley Estate is not interrelated proceedings because the murder trials involving those 4 accused is in no way related to the civil dispute about how the RCMP acted. So there's no need to preserve that privilege beyond the litigation itself. So we're back to that issue of, can the AG protect against Dudley Estate? And you'd think, well, it's a privilege. And your first instinct might be, well, privilege is privilege, and therefore it extends against everybody. But there's actually a fair bit of dicta to the effect that it doesn't. And in a very, very famous decision called Shrews versus General Accident Assurance, the Ontario Court of Appeal said the following: while solicitor-client privilege stands against the world, nobody can get it, right? Litigation privilege is a protection only against the adversary. So you have some dicta suggesting that right off, there's nothing that prevents you from getting that material. And then there's another very famous case called Bydzinski. And this Bydzinski decision, which is a decision of the Manitoba Queen's Bench, is an interesting one. Here what you had was 3 security guards were involved in an incident that led to someone's death in a hotel. And the hotel conducted an investigation for the purposes of protecting itself in civil litigation, and they obtained evidence. what happened was, not surprisingly, the police wanted that evidence. And the court held that they were entitled to it. Essentially, what the court held was the hotel had only sought out that evidence for the purposes of civil litigation and not for criminal litigation. So therefore, criminal litigators were entitled to breach the zone of privacy and obtain that evidence. So Budzinski was a powerful precedent suggesting that this material should be obtainable by Dudley Estate. And the Chambers judge who first heard the Dudley Estate case accepted that reasoning. The privilege is aimed at protecting against disclosure to an adversary. So therefore, the four accused cannot have this material, but that does not affect Dudley Estate. The privilege is confined. It's a very narrow privilege, and it is confined to the same legal combat. So essentially, Dudley Estate was successful at first instance. So again, between Budzinski and the Chambers judge, and some of the dicta I've already showed you, there was good reason to believe that litigation privilege would be read extremely narrowly. But in Dudley Estate at the British Columbia Court of Appeal, the privilege had a bit of a pushback. And here's what they said in Dudley Estate, and I actually think this is a fairly logical conclusion. If the privilege is going to have any meaning whatsoever, it has to operate to protect against everybody. Because essentially what happens otherwise, sorry about that, is that you essentially dilute the privilege by allowing outsiders to have access to it. And that would essentially prevent or ruin the zone of privacy that was essentially created. So the RCMP may well have created these only for the purposes of the four accused, but once you let somebody pierce the privilege, what you're saying is this privilege no longer holds. The zone of privacy is lost because this person has them. And what will happen once that material is actually lost to the third party is sort of unknown. Moreover, there's simply no good reason to turn this over to the third party. The material is much better held as privilege against all parties until that litigation is completed. That's the whole idea of it. Allow you to freely investigate your case without risk of material being turned over indirectly, directly, accidentally, etc. to the other party, which could then make use of it in a way that counteracts the logic of the privilege. In essence, Dudley Estate stands for the proposition that the privilege needs to be maintained until the litigation itself is finished. And I think that's the most important point of the privilege, but it also illustrates the extent to which courts question how important this privilege actually is, because both Budzinski and the decision of the Chambers judge are trying to narrow this privilege, and anybody who follows litigation privilege will see this is a trend in the jurisprudence. The idea that litigators need private space to conduct themselves is becoming of less and less importance going forward as the privilege is weakened by a series of statutory and common law developments. And it's sort of an interesting question going forward about whether or not the privilege is going to rebound. And Dudley Estate is sort of a signal that says no, the privilege needs to be maintained to allow the Attorney General to be able to do its job, prosecute properly without worry of turning over its materials. So essentially the privilege is strengthened at least within the scope of that particular litigation until it ends. Which brings us back to Budzinski. If you remember Budzinski, you had the hotel which investigated the security guards and was, entitled to stand fast with litigation privilege. But the court held that the Crown was able to secure this material and did so using the basis of, well, it wasn't prepared for criminal litigation, so therefore it could be disclosed to a third party, the Crown. Well, Dudley Estate says that this type of logic is incorrect. In fact, it expressly says we're not going to follow Budzinski and the logic that's held therein. But the court did go on to discuss one of the issues of litigation privilege and whether or not, in contrast to legal advice privilege, there is a general exception. And the court, although it didn't decide it because it didn't need to, said, well, in Budzinski, there may well have been good reason to turn this over anyway. And the reason is because zones of privacy should not be able to outweigh the proper administration of criminal justice. And the idea being that where criminal justice requires this material to ensure that a trial is properly conducted, litigation privilege should not be allowed to stand. And I can tell you that going forward in the next 15, 20 years, that's one of the biggest issues with litigation privilege. Will it be held to be absolute, or will it have to stand aside in the context of, competing counter interests? And a lot of people have suggested, in particular leading to this case, in Budzinski, that it just simply can't hold. The privilege is important and will be maintained wherever possible, but needs to be set aside because, frankly, the doctrine animating it is not as powerful or important as legal advice privilege. So Dudley Estate answers some pretty important questions about the strength of the privilege vis-a-vis all outsiders, not just the party you are actually litigating against, but it also raises questions to be decided in future, such as, do we need a generalized exception to ensure that justice at least will take place in criminal proceedings? And if you're thinking, well, what about Dudley Estate? Dudley Estate is the opposite. It wasn't that the material was sought for criminal proceedings, it was the material was sought for civil proceedings, which is viewed as being a much less significant social interest, or at least it was in Dudley Estate. I hope that was of interest to you, and have a great day. To learn more about this topic, you might want to check out my book, The Law of Witnesses and Evidence in Canada, published by Thomson Reuters. This book covers every topic involving the law of evidence and also how witnesses come before courts and tribunals in criminal, civil, and administrative proceedings. To learn more, you can check out my website at petersankoff.com.